Do I need a will if I'm not married? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. Today, let's look at a really common question I get, especially from people who are either not married yet or are no longer married to somebody, and they wonder, do they really need a will? So it's a pretty common misconception that if you are not married, you do not need a will. And I'm not sure where this misconception comes from, but it seems to be a really common question I get from people who aren't married. And I'm not sure why they don't think they need a will. I mean, maybe it could be because they're younger and don't always have as many assets, or maybe it's because they've recently been through a divorce and are very burnt by the process and just don't feel like doing any more estate planning documents, or that feel like that estate plan they did with their ex-spouse should cover things anyway, and they don't realize that actually that plan is probably pretty inappropriate once they get divorced. So for whatever reason, this is a very common question I get from people who are not married, and that's, do I need that will? And I like to change the question a bit and say, well, it's not really just the will, it's more important that we have the estate plan conversation. Because your estate plan is more than just your will. And so if you're a single person, you actually may not necessarily need a will, but you probably need the other documents in the estate plan even more. So one option you have, before you go down this whole road if you're not married, is to talk to a local attorney and find out what the laws of your state say if you die without a will. Because if you die without a will and you're not married, your local probate court probably has a little family tree worksheet or something similar that says what happens to your assets if you die. So after you're gone, we send your assets into the chart and we figure out who is the next person to be able to inherit. So if you're single but you have children, it's pretty simple. It just goes right down to your children. It's usually shared equally between them. If you don't have children, if you have brothers and sisters, they can inherit from you. If you don't have siblings but your parents are still alive, your parents can actually inherit from you, which seems backwards to most people. But I encourage you to have that discussion with a local attorney to find out what the law says. And maybe you as a single person say, you know what, the law and what it would do with my assets, that's fine by me. I don't have kids. I don't have to worry about guardianship of children under 18. I don't have to appoint a trustee, so I'm okay with not having a will. However, there's more than just the will and the estate plan, and let's talk about 3 other documents that are going to be very important for you if you are not married to someone. Document number 1, healthcare power of attorney or a healthcare directive. So this document is a document that tells your doctors, your hospital, your nurses that if I become sick and I'm unable to make decisions for myself, I'm appointing this person to make medical decisions. When somebody is married to somebody else, the doctor easily looks at the spouse and says, okay, your husband or wife is sick. They can't really speak for themselves. What should we do next? It's a pretty simple decision for a doctor to make. But what if you're single and you're in a hospital and you don't have other family members nearby? Who are we going to contact to make those medical decisions? Do they have to track down your parents? Do they have to track down your siblings who may not live nearby? You may be estranged from some of them. They have to track down your kids, but then they find they're under 18. So with the healthcare power of attorney, what we can do is give a clear direction to your doctors, to your nurses, to your hospitals, your other medical providers, give them clear direction that if I become sick, I want this person to be making those medical decisions for me. The next document that will work with this is what we call a living will, and this will be direction for that person who's making decisions about what should happen if you become incapacitated and can't speak for yourself. Do you want them to try to resuscitate you? Do you want them to keep giving you nutrition? Do you want them to put you on a ventilator? All the different end-of-life options. Do you want palliative care? All these end-of-life decisions that you will not be able to make because you're not able to speak for yourself, you're giving direction to the person you've appointed as to what you want to have happen. And so it's not really a document that says this person is the person, it's here's what I would like that person to do. The final document in your estate plan that you need to make sure you're taking care of is going to be your financial power of attorney. So just like all those healthcare decisions, if you become sick, who's going to manage your finances? So a general power of attorney will appoint somebody to be able to manage your finances and other transactions that you may normally encounter in life. They can take care of your banking, your real estate, they can take care of business transactions. Usually your state is going to have a state form that lists like A through N or A through M of all the different powers that you can grant to somebody under your power of attorney. You can also create a separate power of attorney form that has even more things in there than just that checklist and goes a little more in depth. But it's especially important that you have somebody there who can manage your financial life if you become sick and you're unable to speak for yourself. In addition to these 3 documents, I also usually provide a HIPAA authorization so that whoever's making medical decisions can get access to your medical records. And that way they can see the medical records before they're making medical decisions for you. And then finally, people will ask me, do I really need a will if I don't have kids? So if you're single and you don't have kids, and even if you don't have a lot of stuff, maybe you don't actually own any property, you just have a couple of bank accounts and a car, you don't necessarily have to have a will. You can go back to our original example of speak to a local attorney and find out what the law says. But you may actually have some desire to donate to charity. Maybe you want to leave some money to your alma mater, leave it to your church. There's a variety of places you can donate money after you're gone. So a simple will can be used to make sure that you can leave a charitable legacy after you're gone as well. So hopefully you can see that if you're single, you're no longer married, or you just have never been married, it's actually probably more important that you get estate planning documents in place than for your married folks. So if you're single and you need to get started on this journey, or if you have more questions, or if you want to review the local laws in your state and make sure you understand what they say, you can go to my website, 𝙃𝙀𝙍𝙀𝙁. At the top, there's a red button, a legal strategy session button. Click it and you'll be taken to my scheduling page where we can set up a phone call, usually 10 to 15, maybe 20 minutes, and we can go through what your questions are about estate planning. Especially if you're single, we can go through what the laws say and why you need these powers of attorney and other healthcare documents. If you like this video, you can hit the like or thumbs up button below. You can subscribe over on YouTube, and if you have further questions, please feel free to reach out and schedule a consultation. I hope you have a wonderful day, and this helps those of you who are single understand that that misconception that you don't need a will is probably not true.